Thank you. And I think we'd like to just reset the clock to 15 minutes, and we'll make sure that the Commonwealth has appropriate amount of time as well. So I think we are ready.
Justice Sachs, would you like me to start with your question or my introduction?
Well, why don't you introduce yourself for the record, and then I'll ask you the question.
Good afternoon, Your Honors. Mary Miles for the appellant, Christopher Conley.
Okay, and just for the record, we have Justice Shin joining us, as well as Justice Grant and myself, for this final case, which is 22P705, Commonwealth versus Christopher Conley. So I was asking you before we discovered our recording system breakdown, would you agree that regarding the 2009, the Prior Bad Act argument, which is the second argument in your brief, that you argue that that portion of the defendant's confession dealing with the 2009 poisoning, we'll call it, and Dr. Meissner's testimony regarding the cause of the 2009 infections, would you agree that if the defendant's confession was admissible as a prior bad act, and I understand you argue that it wasn't, but if that was admissible or were admissible, then Dr. Meissner's testimony would also be admissible to corroborate at least that part of it that shows she did have, the child did have infections in 2009?
I would argue no. First, I think Dr. Meissner's testimony had very little probative value and very high prejudicial effect. Here, his testimony was equivocal. He suspected that someone inserted her catheter line into feces. Second, it didn't go to the identity of the person who actually did it, even though Mr. Conley did say in a statement that he did. I would also argue that, point this court to the Brown case that said there was really no need to have the corroboration of these, or this confession to the extra robberies, and corroboration is not necessary.
But that is an argument that goes to whether his confession was admissible, not so much whether, if his confession was admissible, Dr. Meissner's testimony would also be admissible to corroborate at least part of it. I'm trying to narrow the issue so that we can focus on his confession to the 2009.
Correct. And I think the argument is that its probative value was very tangential. I mean, I think the Commonwealth uses tangential as the word in their brief. It's hard to imagine how an issue can be so tangential and have so much probative value and not be outweighed by its high prejudicial effect.
Well, on the prejudicial effect, assuming that the defendant's confession is going to come in, and he's going to want to argue this was a false confession, a voluntary false confession, isn't he going to want Dr. Meissner's opinion in then to show where he got the idea that somebody dipped the tube in the fecal matter, that's where he came up with that idea, rather than have it just be out there, this idea of in the confession for the first time? Doesn't he want that in there? Just in the same way that in the the false confession cases, oftentimes the defendant will use a police officer's feeding them the details of the evidence that they then parrot back. So how is it that prejudicial?
Well, because you have an expert. Mr. Conley is, at least at that point we didn't know, but I mean, based on the record, Mr. Conley was going to come in and say, I lied about this, and I lied about all this stuff, and I had a doctor, and this is what they said had happened to her, and this is why I said that. So I don't really know what Dr. Meissner's testimony would add to the defense. I mean, we have Mr. Conley who's going to testify, I fabricated that portion of this false confession so it would make it seem more likely that this actually happened, so it would take attention away from my then wife so that at least MC could be with a mother. I'm not really quite sure he would have any use for Dr. Meissner's testimony, and I don't think it was ever anticipated or called for by defense counsel to have Dr. Meissner testify. And then to, its vicious prejudicial effect, if it was so important to have Dr. Meissner corroborate this 2009 incident, then there's literally no, in my opinion at least, no prejudice on the Commonwealth or the court to allow defense counsel to obtain his expert. I looked through the record preparing for this argument, and I noticed that trial counsel had filed a motion to continue on December 5th. On a December 10th hearing, 2019, the prosecution took no position on whether or not to continue based on the fact that the Commonwealth hadn't adequately responded to these numerous court orders. So, and the court at that point made clear, he's like, I'm not really interested in continuing or changing the trial date, but it wasn't until January 22nd, 11 days prior to trial, that the 2009 allegations or the 2009 mention in his confession, as well as Dr. Meisner's testimony, was going to be admitted. So it's
The notice of the Commonwealth's expert is dated September 18th, 2019.
Yes, but whether or not what prior bad acts, what other uncharged conduct had been litigated for almost a year at that point, and the Commonwealth kept on trying to introduce, at least according to the motion court, almost her entire medical record. And then it was so overbroad that how is a defense counsel supposed to know, well, if I don't know what, you know, if I have to retain an expert for every single one of these allegations, it's beyond costly, it's unmanageable. So just because they say, well, we intend to call this expert, but I still haven't given you the full scope of the prior bad acts, it almost makes this September 18th notice moot. So, and then I would also argue that...
What would the hypothetical expert have said? That there would have been other causes for the infection that she had in 2009, and therefore, and then he would argue, and therefore, my confession as to the 2009 incident was fabricated, and therefore, so was the rest of the confession? I mean, what would the expert have said?
Well, I mean, this was clearly a controverted issue about whether or not what actually happened or whether it was intentional or whether he had something to do with it was controverted. The expert would have said that her infections were caused by nurses, were caused by different things we don't know because he wasn't given a chance to obtain an expert.
Well, I mean, Dr. Meisner never testified as to, he only testified as to the cause of the infection, as to what caused, not who caused the infection, but what caused the infection. So you're saying hypothetical expert could have opined as to other medical reasons for the infection?
Yeah, I mean, that's what I'm saying. I mean, if his testimony is so probative that we need to compound this error and keep on having a trial within a trial about 2009, there's no reason to not give him the opportunity to 30 days or so to try and find an expert to even cross-examine him. I mean, if you look at the cross-examination that trial counsel Godleski gives, I mean, it's a lot of, well, this is what you said in your note, this is what you said in 2009. They keep on feigning a lot of memory loss. It's almost kind of a lame duck cross-examination. If he had been able to get an expert to go through these medical records, to be better able to fully explain what would have happened, then the cross-examination would have been more effective. I mean,
he had a lot of experts.
Correct.
And including those that were experts in infection and pediatric infections and the kinds of conditions that the victim had. So, I mean, I haven't seen anything specific about what line of questioning an expert would have suggested for cross-examination that would suggest prejudice.
Well, I think the prejudice comes from the fact is here we have this reference in his statement to 2009, right? And they say this is horrific acts that happened that the Commonwealth is alleging in 2015, right? No one can fathom that a parent is actually going to do this.
I guess by prejudice, I mean yes, the continuance was denied, but what would an expert have gotten you? What line of cross-examination could have been pursued but wasn't? Now, I understand that since you don't have an expert,
my
hands
are kind of tied with that, I mean, the only thing I can say is that in this record, we know that MSC was ultimately returned to her parents. So at some point, this gets to the judicial notice issue, but at some point, a care and protection judge or a family court judge dismissed this hearing and ostensibly found these allegations to not be true.
Well, but there was
it's not quite as conclusive as saying, well, he said I did this in 2009, and we have this other doctor that says these infections are definitely caused by this, intentional, or we suspect they're caused by the intentional dipping.
He hadn't even said that in 2009. He hadn't even said they were
No.
caused by something intentional, so that wasn't an accusation against the little that we know about the care and protection proceeding, that wasn't an allegation against the parents. Certainly, the defendant hadn't confessed to it back in 2009, falsely or not.
Correct.
So I'm trying to think what an expert with a continuance could have said, that she didn't have these infections, that the infections, it doesn't seem to be controverted.
We know that she had these infections. That's not controverted. I think, the whole issue is what caused these infections. Dr. Meisner's, we keep on talking about the prejudice, but then what is the probative value of what he's saying? That's what I'm saying. So we have this medical expert who's going to say that I suspect that her catheter was intentionally dipped, and then we have his statement, in his May statement, that I did this in 2009. Its prejudicial effect is so high, but if he's not able to say, I definitely think he's the one who did this, they might have been caused by intentional dipping. If it's so equivocal, then what is its probative value, I guess, is what my big problem with that.
The probative value, assuming that the statement came in properly, is to corroborate the statement. Right? Let's say.
Yeah, but we're not corroborating. Then I think we go to the question of what probative value is to corroborate allegations of the crime of what he's not charged. It's not corroborating allegations of what the crimes if he was actually
It's to
charged,
show
right?
that the prior bad act actually occurred. Let's say instead of, a confession, you had observations. Someone observed him starting to do what he confessed to. And he said something like, I just want to put her out of her misery. That would be admissible as to motive, right?
Yeah, but that's all. But we have someone observing him here.
Right, so now he's here. We have a confession.
Correct.
And the Meissner's testimony is probative, it seems to me, to corroborate what he said happened.
In 2009.
Right.
But I'm saying that whole issue in and of itself is more prejudicial than probative. Here, the judge admitted it to motive, intent, knowledge, opportunity, et cetera, all these things. But if you look at just the 2015 issue, all of that's presented in his May statement. It kind of becomes cumulative. And the prejudicial effect of this evidence is so high. It gives the...
I guess what I'm confused about is what independent prejudice was caused by Dr. Meissner's testimony as opposed to the statement in the confession about the 2009 incident. Going back to Justice Sachs'
Yeah, no, and I think it's a fair question.
If the statement came in properly, why did Dr. Meissner's testimony really add to any unfair prejudice?
That's a fair point. I think, kind of colloquially, it's an expert corroborating, saying, yes, what he said as to 2009 actually happened, right? And so if you look at the totality of the trial, we have Mr. Conley and the Commonwealth produced experts ad nauseum on both sides about 2015, right? So they're left an issue of credibility, and maybe this happened, maybe this didn't. But then we have this 2009 incident come in, and the Commonwealth puts forth his statement, and then he says, no, I'm lying in that. And then the Commonwealth gets to put in another expert. It's kind of like, oh, well, if he was lying about that, and he put all these other experts to refute 2015 allegations, why wasn't there an expert to refute 2009?
I'm sorry to interrupt, but
I'm sorry,
you're
Your Honor.
probably looking at the clock. You have a lot of issues. I
know, I'm sorry.
Some questions about the first aspect of the ineffective assistance claim, which I don't really understand. So you can talk about whatever you want, but I do have a question about your theory on which once the defendant was cross-examined, the statement to Attorney Goodman Park would come in as a prior consistent statement. And I don't understand your argument or the Commonwealth's about what the relevant motive is and when it arose.
So I would argue that the Commonwealth argued on cross-examination that his May statement was true, and when he gave that statement was true. And it's only now that he is facing criminal conviction and he had his daughter permanently taken away by care and protection. Now he's saying, oh, no, now I'm lying, and it's actually not true. Mr. Conley should have been given the legal opportunity, or the opportunity to say, prior to giving that May statement, I had told someone else that this was false. This isn't some recent contrivance that I came up with now that I'm facing, this criminal conviction.
Because he wouldn't have known back when he said when he spoke to
Attorney Park.
Attorney Park, that criminal charges might ensue from his statement?
Yeah, he probably did. I'm not saying anything that he said was logical.
He testified on direct that he knew he would be arrested when he made that statement.
Yeah, I agree. Nothing he did was logical. And nothing that happened in this case was logical. I'm saying that the Commonwealth is now saying that he's only now recanting his statement after he gave his May 20th statement. He told his attorney that he wasn't going to give that he was giving a false confession. I know my time's about to run up, but it seems to me a little illogical that this man who has no criminal law experience is going to tell an unrelated attorney that, hey, I'm going to give a false confession. I didn't do it. This is what we do for a family. It's going to somehow be able to use to bolster his later recantation. He's not a criminal mastermind here. It's just...
Well, you don't have to know the rules of evidence to know that if you tell someone something before you do it, then they'll be able to corroborate what your plan was, whether that was your actual plan or not. He doesn't have to know about the rules of evidence and prior consistent statements to think, hey, if I'm going to play this dangerous game here of telling, different people different things, why don't I plant the seed to establish that I was planning to lie about it all along?
And I think that's the Commonwealth's argument. I argue that it's a little bit more narrow than that. I think that the Commonwealth argues at trial that this is a recent contrivance and that he's only now doing this because he's facing criminal conviction and facing trial, and that his daughter was permanently taken away. This is kind of the theme that happens throughout the Commonwealth's cross-examination. So I think in order to refute that, be like, before all this happened, and I said I was going to, give a false confession.
Well, but the Commonwealth on cross-examination, I'm looking at transcript 21 or 11, depending on how you count them, page 171. Instead, you decided to falsely confess to poisoning your daughter, correct? Yes. Which you knew would result in you losing your freedom, correct? Yes. So the Commonwealth is not suggesting that he just made this up once he was charged. They're saying you knew when you confessed that you were going to be arrested for it, and he's agreeing. So how is that suggesting a recent contrivance that he only decided to recant after he was arrested, or after he was charged, or after he lost his daughter?
Because they're claiming he's lying in his trial testimony. He said, yes, I knew when I gave this false confession. Yes, I knew when I spoke with Detective Bresnahan that I would be arrested. And they're saying, but now you're saying you're lying. And he should be able to say, now the Commonwealth's alleging him of lying in his trial testimony and saying, no, but now you're recanting this testimony. So I argue that, he should be able to say that, prior to giving this statement, prior to, all these criminal proceedings, whether he knew it was going to happen or not, before, the weight of all this happened, he did tell an unrelated attorney that I'm going to falsely confess. I would argue that that's his ability to counter that Commonwealth's narrative that, he's only now testifying and he's only now lying about, giving this false confession. I think it gets really complicated since we're talking about the defendant's testimony about giving a false confession that the Commonwealth is alleging is true and the defendant is alleging is false.
I agree it's really complicated.
Yes, yes. I know there are a lot of other briefs, but I'll rest on my brief for the rest of the issues.
Further? Okay, thank you. Ms. Lynch.
Good afternoon, Your Honors. May it please the Court, Bethany Lynch, Assistant District Attorney for the Commonwealth. If the Court is okay with it, I will address the issues that you raised in the order in which they were raised, starting with the prior bad acts issue. The trial judge in this case assessed the offer of the Commonwealth that the incident from 2009 would be introduced as a prior bad act, and weighed all of the various arguments and the prejudice and the probative value of the argument of the evidence, and found that it was an admissible piece of prior bad act evidence.
I want to focus on what it proves. And the judge ran down a number of things. First was motive.
Yes.
How does it show motive?
It shows that it was a similar motive then and now, and the motive being to put his daughter out of her misery. Twice his daughter was in the hospital, or I'm sorry, twice his daughter was very sick, and twice it's motive combined with an MO, in that in both times he sought to put her out of her misery. That is why he acted in the way that he did, and he acted consistently twice. He acted consistently as well.
How is that not propensity evidence? He did it once, therefore he'll do it again.
It's because it doesn't stand alone like that. If it was just he did it once, he would do it again, the Commonwealth would agree that that would be propensity evidence. But here, the detailed nature of what he's doing, he's maneuvering her medical apparatus. He is putting toxic, poisonous things into her various bodily systems. He's done that on one occasion, and then he did it again a second time. So it shows his opportunity. It shows how he has the ability and the access.
There was no dispute that he would have had the opportunity, was there?
There was, no,
It's
no,
clear
no,
that
as
he
the
was
parents,
dealing-
like, initially, it is, I think, significant to point out as well, that initially both parents were charged. So there was both parents had equal access to the child. The mother was with her more often. The father did work. But no, they both did have opportunity.
And similarly, knowledge. I mean, it's clear that both parents must have known about her medical equipment. That wasn't controverted, so.
I don't think the fact that it's not controverted precludes the Commonwealth from
It
offering
doesn't preclude
evidence
it,
of it.
but the incremental value of the 2009 allegations has to be weighed against the prejudicial effect.
That is true. That is true. But I would suggest
So where
that.
it wasn't controverted, the probative value is diminished.
Well, I don't know that controverted would be the right word, but the defendant, until his confession and in his defense was that I didn't do any of that stuff. I wasn't there. It was my wife who did it, or I believe it was my wife, or that. Those were the things that he brought up at trial. So part of the 2009 issue is showing that he himself, he implied in his testimony and a lot in his statement as well that his wife was the majority caretaker and that she did the majority of the medical interactions with his daughter. He was there and he knew how to do this stuff, but she was there most of the time. So
Did he ever argue that his wife did it?
not specifically.
Okay,
No.
and did he ever suggest that he didn't have access and knowledge of how her, I mean, didn't he give her
No, he knew how her
saline
tubes-
flush?
yes, he
So
did
his
know how to do
knowledge
that.
wasn't at issue. That didn't need to be proven by going back to what he did in 2009.
No. In order for us to prove his knowledge, we did not need that piece. But it was the combination of all of the different pieces that the 2009 incident demonstrated. It did demonstrate his knowledge. It did demonstrate his opportunity. It did demonstrate his motive and the fact that what he did two times.
Why wasn't his motive, I mean, he confessed.
He confessed, but
Whether
he-
falsely or not, he confessed prior to, this came in the Commonwealth's case, ain't it?
Yes.
To put her out of her misery. Why does it need to be corroborated by showing that he had a similar motive or confessed to a similar motive in 2009?
I would suggest that it needs to be corroborated because of the very fact that he was recanting his statement and saying that he did not do this. He was lying when he said he wanted to put her out of her misery.
Okay, but he recanted them both. That raises the issue of the Brown case about how does the evidence about a fabricated confession to something you weren't charged with corroborate the accuracy of a confession to something you were charged with?
Well, I would suggest that it does corroborate it because of the nature of what he's confessing to. He's confessing to tampering with the medical apparatus and the fact that of anything that he could possibly, this child's medical records were abundant. There were many, many, many things that he could have added if he wanted to add a extra corroborative detail or something. In this case, this was a specific incident that he chose to include in his statement to the police. And not only was it a specific incident that was very close to what he did in this situation, but it was also one that could be proven by medical records to have actually happened. So it's not
He was tailoring his confession and I think this point came up he was tailoring his confession to the facts that were known and had been intensively scrutinized, I suppose, in the 2009 care and protection.
Right, but from the Commonwealth's perspective, we are offering that evidence not to prove that he's catering anything, but to prove that he did it. He did it in 2009, and it is so close in means to what he is doing now, and
Isn't
it is
that
something
usually-
corroborative to prove the overall truth of his confession.
Correct me if I'm wrong, I probably am, but isn't that sort of MO approach to prior bad act evidence used when there's a question about the identity of the, who perpetrated the charged offenses?
Well, and I would
So
suggest...
if you can show, he had a particular, back in 2009, he robbed a bank in a particular way. 2015, someone else robs the bank in the exact same, very unusual way.
Right.
Therefore,
But in this
probably
case,
him.
he is denying that he did it in 2015. He's saying, I did not poison my daughter in 2015. And so I would suggest that the fact that he confessed to poisoning her in 2009, the MO does go to the identity of the perpetrator. The Commonwealth does not believe there's a question of who did this, but the defense was claiming that it wasn't him. And somebody violently and vehemently, well, not violently is a bad word, but someone very severely injured this child, and he's saying, it wasn't me. I confessed to it, but it wasn't me. And that was his testimony. So the Commonwealth had the right to corroborate pieces of his statement in order to undercut his recantation and to prove who did injure the child.
So how do you deal with the Brown case about the,
Well, I think that the Brown case would be distinguishable because, I'm sorry, I'm not all that familiar with the Brown case, and
in the Brown case, the SJC said it's difficult to see how the alleged confessions to uncharged robberies
Right,
serve to
okay.
show that the confessions to the charged robberies had not been fabricated. The defendant was charged with some robberies.
Right.
Police testified that he'd confessed not only to the charged offenses, but to a bunch of other uncharged offenses of which they had some records in their files.
Okay.
And the defense says all this was fabricated, and the police testimony is, well, look, he confessed to these other ones too. And the
Right, but
SJC says, how does if the confessions to the uncharged robberies were fabricated, how does that show that the confession to the charged robbery was not fabricated?
I think that's where Dr. Meisner's testimony comes in as well, because Dr. Meisner's testimony establishes that the 2009, the confession to the 2009 act was not fabricated, because it shows that exactly what he says he did in 2009 resulted in the polymicrobial infections that this child had.
Yeah,
And
unless,
there was-
of course, he fabricated the confession. I mean, the difference between Brown and this case is that in Brown, it was the police fabricating, and here it's the defendant who claims that he fabricated it. But he fabricated it to fit the facts that he knew, which included that she'd gotten these very bad infections.
But I think it was more than that, though, because he knew that she had gotten bad infections in the past, but he was not so knowledgeable that he understood, I would argue, or there's no evidence that he knew that the thing that he was confessing to from 2009, which was dipping, it was important that it was dipping a central line into fecal matter, and then returning it to the central line. That caused a polymicrobial infection in her bloodline that could only have come from bacteria that are found in the intestinal tract. So he would have had to have known that level of detail to understand that. I think it's giving him way too much credit to think that he knew all of
testified in
that.
2009,
Yes.
I mean, not necessarily to dipping, but didn't Dr. Meissner testify that those bacteria were ones that were only found in the digestive system?
I believe he did testify
So,
to that.
and
It was difficult because we
was that
didn't
as a
have-
part of the care and protection case?
Yes, the 2009 care
Okay,
protection
so
case,
wouldn't
yes.
the defendant have had knowledge of what Dr. Meissner testified then?
Yes. I hadn't thought of him being present there, but yes, he would have had some knowledge of that, but, I mean, certainly he could have created this entire thing in a mastermind way from the minute his daughter went into the hospital or the minute that DCF came to them in 2015. But I would suggest that what we had here was a confession from a defendant to injuring his child with liquid plumber, and that fit with all of the medical diagnoses that followed, all of the medical injury that she suffered were corroborating of that statement. He also, in that statement, and I would suggest in part of this conversation he was having, he said, and it's not the first time I've done this, I tried to hurt her before, and this is the means that I did that. I think that that does go to his motive. It shows the same motive. It shows that he had, when he has opportunity, he will do things. He has done this before. It does show the modus operandi, and it does corroborate the truth of his statement. And all of those things were presented to the trial judge. The trial judge heard them. He weighed it, and he found that while, of course, it's prejudicial, it does have a significant probative value. Also, it's important to note that the jury was instructed on exactly how to use prior bad act evidence.
May I ask you about the statement to Attorney Park?
Yes.
That was, defendant offered it as a statement of present intention, and the
Yes.
judge said it's not one statement, it's three.
Right.
If the statement had been, I'm going to make a false confession to the DA, would that have been admissible as a statement of present intention?
It would have been closer to being a statement of present intention.
Well, would it have been admissible? We know, we have the Vermette case.
Yes, we do. I would suggest that may have been. That may have been, because that was, he was saying what his intention was, that his action that he was saying.
So how is that different in substance from saying, I'm going to give the DA a confession, I didn't do it?
Because this is all hearsay, I would suggest that that it is appropriate to parse them out into the individual parts. Because none of this is admissible because it's hearsay, because the defendant is the one offering
Unless
it.
it's a statement
Unless-
of present intention.
Right, but a statement of present intention is an intention, as the judge found, to do some sort of an act, to make a confession, which is, and
But
that
the-
statement he found was admissible. I'm going to confess. That is a statement of intention and an action statement.
So you acknowledge that the statement, I'm going to make a false confession, would be admissible, but I'm going to make a confession, I didn't do it, would not be admissible.
Yes, yes, because I didn't do it is a hearsay statement by a defendant that does not fall under an exception.
But why isn't the word false equally a hearsay statement in your view?
Because that, if it's in the sentence with what he's going to do,
So
what
it all
he's
depends
stating
on the
he's going
word
to do.
order or the punctuation?
I would suggest that it is dependent on the statement that the defendant made. If the defendant is trying to offer inadmissible hearsay under an exception, he's trying to offer his own statements.
Sure.
So if he's trying to offer that statement, the statement itself and what is said in the statement is highly relevant to the judge's analysis.
Okay, but in substance, do you agree that what the defendant allegedly, well, I guess,
I mean,
assuming we believe Attorney Park.
right.
He said to her, I'm going to give the DA a confession. I didn't do it. We can leave off the part about that's what you do for your family.
Yeah.
Isn't that in substance, I'm going to give the DA a confession to something I didn't do?
It would be. It would be
Yeah.
in
So-
substance. Again, if it's one sentence, but I
Okay.
think the fact that it's two sentences means that I didn't do it is just a straight denial.
So if there were a comma or a semicolon there, it would be okay, but if there's a period there, it's not okay? And this is all what, is this someone's transcription of what she said in the video interview, which
Yes,
I
this
at
is
least
what
have not
she-
yet.
That's what I was going to ask. Where are these statements and the order of the
They
statements coming
are
from?
in, I believe, and I'm going to defer, but I believe that it was a recorded statement with Attorney Parks. She gave a statement, and I believe that you have the recording.
We
Did you
do,
send
yeah,
it
but
out?
where is
Yes.
it in the, there are 4 videos, each a gigabyte.
Oh, I'm sorry. That
Sorry not to interrupt,
Please.
sister, but I believe I did, and if I didn't, I'll put in a 16L letter.
Yeah, I can too.
I put the citations in a footnote and how to read the videos in the brief. If I did not, that is an absolute mistake on my part, and I will write you a 16L letter. Maybe I had done it in one of the other briefs, but I think I gave a citation as to how to read the videos and the exact placement in the videos where Attorney Park said this.
Okay.
So is she giving kind of a summary of what he said? I mean, so we don't have an actual recording of what he said.
No, we have no recording of what he said.
So we don't really know how these statements came out. So.
Right, but I would suggest that's not the Commonwealth's burden.
Right, so.
Yeah.
Let me just finish.
I'm sorry.
the thought. So if he had actually said, I'm going to confess, then he says a whole bunch of other things, and then he says, oh, by the way, I didn't do it, just so you know, that would be inadmissible, right?
Yes,
Okay,
yes.
so we don't actually know how these statements came out.
No, we know it was, the way it was proffered and accepted by all the parties was this three-sentence.
Was it stipulated or agreed that these three
It was
statements came in
in both.
succession?
It was in the filings, and that's what the judge adopted, as it being those three separate statements.
But that it was said in a row without anything in between?
Yes, yes.
So that was agreed to, that it was said, those three
I don't know that
statements-
it was as agreed to as it was not objected to. It wasn't contested that it was said in that way.
Okay.
So, but again, I believe that the motion judge, who did have access to all of this information, he viewed those as three separate statements. And he felt that I'm going to confess would fall under the hearsay exception because it does offer an affirmative
But not
action that he's
relevant.
going to play. I mean, if he wanted to offer that, Commonwealth would not have objected, but the rest of it was not an affirmative action, and it was merely self-serving denial that he was making to his counsel.
Do you want to try to explain the business about the first aspect of the ineffective assistance claim?
I'll give it a shot at this point. So the defendant offered these statements initially. He was going to offer them as with the hearsay exception. The judge rejected that. And so at the time in the trial, he said, I will maybe offer it later as a prior consistent, and then never did. So part of the motion for new trial was that.
The judge said it wouldn't have been admissible because he had the motive all along.
Right.
Can you explain that?
Right. Explain, well, I mean,
Why it wasn't an allegation of a recent fabrication? Is that the basis on which the judge?
No, I agree that there was, that at the time.
That the judge said the statement to Attorney Goodman Park did not predate the.
No. He found that
fabrication.
it did predate. No, it wasn't that. It's the fact that until the defendant testified, he had not actually formally recanted. We knew he was going to, just in that what his attorney had represented, but the defendant had not gotten on the stand and recanted his statement. So the Commonwealth offered it with backstops for corroboration for our case, but until he testified in his case, he hadn't formally recanted it in terms of any kind of a filing or in terms of, I believe, like an affidavit or something like that. So when he testified and recanted his confession, at that point, he has now, that is new. That is, I don't know if recent contrivance is exactly the right word, but it was, sorry, I lost my standard, but that was new. So the first part of the test for prior consistent statement was satisfied, and the trial judge agreed, and the Commonwealth doesn't contest that he did meet that part of the foundational requirements to get in a prior consistent statement. The Commonwealth's position was that, but even though we did challenge it as something you're recently telling us, he had the motive to fabricate all along, so therefore the trial judge would not have allowed the testimony in as a prior consistent statement anyway. And the trial judge agreed with that, and having heard argument and briefing from both of us, he issued his motion for new trial findings, saying that even if it had been offered, even if the attorney had offered it at trial based on his finding that he had a motive to fabricate when he was talking to Attorney Goodman Park, as far back as then he had a motive to fabricate his statements to her, he would not have allowed that in as a prior consistent statement. Did that make any sense?
Well, I'm looking at the words. I'm looking at the words in the new trial ruling. He had from the outset, the defendant had both a motive to confess in order to try to ensure the child would remain in her mother's custody, and to claim that the confession was a fabrication to avoid conviction himself. So,
That's
in other
right.
words, at the time he told Attorney Goodman Park he was going to make a false confession, he already had a reason to lie about the falsity of that
Right,
confession.
so that's the second, so in order for the prior consistent statement to come in, the defendant would have to establish two things foundationally. The first being that the Commonwealth challenged this statement as being recently contrived, which we agree that we did by challenging, saying, oh, now you're recanting. We did challenge that, and that the statement has to be made before he had a motive to fabricate. And the motion judge, who was the trial judge as well, found that it was not made before he had a motive to fabricate.
Well, saying he had a motive to fabricate about the falsehood of the confession assumes that he's guilty, doesn't it?
It assumes that he's going to tell, assuming that it's true, it assumes that he's going to tell the police something untrue. I think that's about as far as that statement will go.
All right, well, thank you.
Thank you. If you have no further questions, I'll rest on my
Very
brief.
well argued on both sides.
Thank you. I didn't think they were